you probably know my story, but this is the very, very short version of it. I'm one of hundreds of women and men who've been discriminated against and harassed at work for saying the honest truth about men and women. In 2019, I took my employer to tribunal on a discrimination claim, belief discrimination, and I lost. And then I appealed and I won, and I finally completed my claim last year and was awarded damages. So that's the very short story. In fact, I think it started here. This was where Lesbians on Chairs was, wasn't it? That was the very, very first time I stood up. I put my hand up and I said, and people had already heard about the case, and it got big cheer. And that was right when I was launching it. And so I had to claim that the belief that sex is real, sex is immutable, and sex is important is a philosophical belief. Is that still on? Yeah, okay. Which seems a bit odd, but that's what I had to do in order to get this case to work. And that created a precedent that many other people are using at work and as service users. And that judgment's got my name on it, and I feel quite proud about that. But if it wasn't me, someone else would have done it. There have been 6 cases since, and someone else would have done it because the law that it rests on is really well established. And it's not just the Equality Act, that the Equality Act protects against discrimination based on religious or philosophical belief or lack of belief. It's that underlying that is the European Convention on Human Rights. And underlying that is the Universal Declaration of Human Rights. And it says that you have protection for freedom of expression and freedom of belief. So this isn't something I invented, but I'm glad my name's on it. And so Article 9, freedom of thought, conscience and religion, says everyone has the right to freedom of thought, conscience and religion. This right includes freedom to change his religion or belief, and freedom either alone or in community with others and in public or private to manifest his religion or belief in worship, teaching, practice and observance. That's what we're doing here. We are manifesting our belief. But that freedom is limited. It's not an absolute right, and it's limited, subject only to such limitations as are prescribed in law and are necessary in a democratic society. That's where the whole catchphrase about whether it's worthy of respect in a democratic society comes from. It means whether the government can legitimately constrain your right to manifest your belief in all or any situation. So that the first hurdle you have to get over is that the belief is worthy of respect in a democratic society, is worthy of protection by the state, and that the state mustn't constrain it. So that's where that came from. And the important thing about that, human rights are universal. The right to freedom of belief covers good beliefs and bad beliefs. It covers beliefs that are offensive and inoffensive. It covers beliefs that are frankly wrong, and that we don't like. There are all different things that we like and don't like. And freedom of expression includes the freedom to lie. The government can't stop you lying. It can stop you lying in some situations, but it can't stop you lying in general. So freedom of belief and freedom of expression are not just for the people we like. And if we want to be protected by them, they're also protecting the people that we don't like. But those are limited rights. So there are situations where the government can say, no, you don't have the right to lie in this situation. You have to tell the truth, the whole truth, and nothing but the truth in court, filling in a form. So the question is, which are those situations? And that's really where this issue of what the balance of rights is. People talk about women's rights versus trans rights, but it isn't that. It's my right to freedom of expression versus your right to privacy, or it's someone else's right to freedom of expression versus my right to privacy, or my right not to hear what they want to say. And J.K. Rowling, I think she summarized it perfectly in her tweet. She got it all down into one tweet when she said, dress however you please, call yourself whatever you like, sleep with any consenting adult will have you, live your best life in peace and security, but force women out of their jobs for stating that sex is real. That's what she tweeted after I lost. And that it's basically the whole of the European Convention on Human Rights condensed into one tweet. And so since my judgment, a bunch of things have happened. There have been 6 big cases. There have been 6 wins since my case. Alison Bailey, Denise Farmy, Rachel Mead, Joe Phoenix, Shara Ali, and Ros Adams, and there are several other cases on the way. Each one of them added something new. So Alison Bailey's case showed that the kinds of beliefs that protected are not just the vanilla gender critical trademark belief, which was mine. Mine was very basic. There are 2 sexes, and that's important. Alison Bailey's belief included Stonewall's campaigning position is sexist and homophobic, and that was covered as a belief. So, gender critical beliefs are not all the same, and any belief that meets this test of being worthy of respect in a democratic society is protected. Denise Farmy won on harassment, so she didn't win on discrimination. The case wasn't about discrimination. The case was about harassment, and harassment is where an employer or a service provider it's unwanted conduct that has the effect of violating the claimant's dignity and creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. And what happened in Denise Farmy's case was that she defended LGBT Alliance within the Arts Council, and some of her colleagues took offence to that, and they made a petition and they sent it all around the office saying it was a petition against LGBT Alliance, but because she'd been the only person who'd stood up for them, it was really very directed at her, and it said, some of our colleagues have discriminatory and transphobic views. And that was found to be harassment against Denise. And they also called LGBT Alliance a glorified hate group, and neo-Nazis and all the rest of it. And all of that was found to be discrimination, harassment, because her employer. They did take action eventually to take the petition down, but it took them 24 hours, and they messed around with it. But you can see how employers are now in a difficult position, because Alison Bailey's belief that Stonewall is homophobic and sexist is protected, and Denise Farmy's belief that LGBT Alliance is a good thing is protected. And employers, they would just really rather people would leave their philosophical and political debates at home. And often that's the best thing. People shouldn't be arguing about Israel and Gaza in the workplace. They should mainly just be getting on with their job. And I think the more employers sort of do that and don't say bring your whole self to work, is probably the better. But they do have to protect everyone in the workplace. They have to protect everyone fairly. And then Joe Phoenix, it was a similar kind of case in the university, Rachel Mead in social work. And then the most recent one, Ros Adams against Edinburgh Rape Crisis Centre. Yeah. That was different, because that was a situation where it really wasn't about whether you were bringing your political views to work or not. It was about how the centre operated. And the difference between talking about Israel and Gaza and talking about whether sex is real is that in any situation where sex matters, you have to be able to talk about whether sex is real. And in almost every situation when there are people in a room together, sex matters, but particularly in a rape crisis centre where a client was asking Ros Adams, is this person she's going to see a man or a woman? And it was a woman. It was a woman who was non-binary. And she got in trouble because she was trying to protect the non-binary woman's sensibilities, but also trying to be truthful and honest to the client and say, yes, don't worry, you are going to be seeing someone who's female. And the interesting thing, I think, with the cases also, these 6 cases, they get madder and madder. So my employer was kind of hapless, and Garden Court was a bit hapless. There were people in Garden Court on both sides of the argument. The OU, something similar, and the same again in Westminster City Council. And then, but they were captured. Each of them is more and more captured by the activists within. And then by the time you get to an Edinburgh Rape Crisis, the whole organisation is mad because they've adopted gender ideology. And you read the judgments. My judgment is quite grudging. She's not a Nazi. maybe she has some rights. And by the time they get to Ros Adams, they are kind of saying, what is this thing that's taken over our institutions? So all of that has been painful but good in the end. And then, as well as these 6 cases that have gone to court at great expense, pain, and all of that, there are all the other cases that have settled, and all of the investigations that have gone away. And people come up to me and tell me things at meetings like this, or people DM me and say, there was an investigation at work, and I said your name, and it went away, which is brilliant. And those things never get counted, but they're important, because this, gender authoritarianism is a war against women, but it's also a war against competence. It's just a war against people being able to do their job. And if people put their foot down and say, no, I'm good at my job, I'm doing my job, what I'm saying is not unreasonable, back off, and people back off, that's the best outcome. Third thing that's happened is there had been a case in Europe. So there was a case in Norway, Rihanna Vogel's, quite similar to mine, and she won. And the thing about my case is, because it rests on the European Convention on Human Rights, because it rests on the freedom of religion and belief, which is protected across Europe in every country's employment laws, there should be other cases in other countries in Europe. And then the other important thing that I think has happened because of my case, or because of this precedent, is about us being able to organise collectively. So it's not just that it protects individuals at work when they're being reported and harassed and investigated, but it means that if you're a group that is organising on gender critical lines, they can't discriminate against your group in a situation where the Equality Act applies. And so we've seen all these sex equality and equity networks sparking up. The first one in the civil service, then in the city, the police, the NHS, teachers. We had a meeting yesterday and there were 23 different sector groups there. It was quite exciting. And things like LGBA managed to get charitable status and retain its charitable status because the belief is worthy of respect in a democratic society. And getting charitable status means not only that the thing you're saying is lawful and respectable, but that it's recognised as being in the public interest that you're able to say it. And people can say things that disagree with you in the public interest. It doesn't mean that every charity is right about everything, but you have to jump through quite some hoops to get it. LGBT Alliance did that, Sex Matters did that, and that gives us a bit more legitimacy. And then just things like Joe Phoenix the other day set up a listserv for university academics to talk about gender critical things with a gender critical perspective. It's just sort of normal people doing normal things as if this was a topic that wasn't the weirdest, most dangerous thing in the world. That's what this opens up. And that means politicians talking about it, journalists talking about it, academics particularly. And we got the Cass review, which I think has been a huge game changer. Puberty blockers have been banned. Things like the UK Council for Psychotherapy backing out of the Coalition Against Conversion Therapy. All of this is because of being able to have conversations within professions in normal ways. So I'm not taking credit for any of this, but I think it has changed since we were sitting here in 2019 when I first put my hand up, in terms of how dangerous or safe it is to talk about this. And another result of that has been that Stonewall's influence has been reduced. So if you look at the Stonewall Workplace Equality Index this year, got almost no central government departments and agencies in it. It does still have universities in it. It does still have police forces and other people who should know better and should be following the Nolan principles. But all of the central government departments, who used to make up about a third of it, have gone. Alison Bailey's final judgment is coming out on Wednesday. So she sued her chambers for discriminating against her, and she won. She also sued Stonewall for encouraging her chambers to discriminate against her, and initially she lost. and she appealed on that. So it's a very kind of legal question about to what extent, and not many people have ever used this bit of the law about encouraging another party to discriminate. So it's a sort of test case, not particularly about the content of the gender critical beliefs, but about how far that chain of responsibility can go back to Stonewall. That will be very interesting if she wins. So it's powerful, but it's important, but it's not all powerful. And we need to remember that. One thing is the Equality Act doesn't cover all relationships, so it only covers your employer's relationship with you. It covers a service provider, including public service or private service. It doesn't necessarily include a sort of freelance relationship, although it did include mine. So some relationships between publishers and authors, for example, will not be covered in the same way as if you've got a job. And so that means people can still be discriminated against. And in any case, it's good to have a good employment tribunal, but it's better to have a good job. And you can win and still be made unemployable within the sector. Other people have rights, and this is important. It's important that other people have rights. So, as the judge said in my case, he said, you cannot misgender with impunity. If you read the paragraph before that, he said, we can't stop you misgendering all the time. They never quote that bit. What he said was, we can't have a blanket ban against misgendering, but if the thing that you do that is called misgendering is harassment, then you're not going to have a get out of jail card because you are gender critical. The same way, if you called someone divorced, if you made a big thing about the fact that they were divorced, or they were a woman, or they were old, these things can all be true about a person, but if you bang on about it at work, that could be harassment. So it wasn't saying that misgendering is a special class of thing. It was just saying, if the thing that you do is accused of being harassment, then you're going to have to defend yourself in the same way that you would with any other set of words. And I wish he'd said it better, and I don't think he really understood quite the environment we were in, but that's what that bit means. The courts have been neutral because we've asked them about belief discrimination. They have to be neutral as to one belief or another, because that's how belief discrimination works. It protects atheists, it protects Catholics. It doesn't say which one's true or not. And so when you ask them about belief discrimination, they always say, we're neutral as to the facts. But that doesn't mean everyone has to be neutral about whether sex is real or immutable all the time, because that way madness lies. It's just not what you're going to ask a tribunal to judge. If someone's running an organization, they need to understand that there are two sexes, particularly if they're protecting people. And that, I think, started to show up in the Edinburgh Rape Crisis Centre. It didn't make sense to run a rape crisis centre and pretend that sex isn't real or doesn't matter. And the nurses in Darlington and the nurse in Fife who are bringing a case. So these are nurses who, they're changing before and after their shift, and there was a male doctor who identifies as a woman in the changing room, and they said, this is harassment, this is creating a hostile, intimidating environment for us. And their employer said, but it's a lovely woman. And they said, no, it's not. And they're going to court, and that will be belief discrimination, but it will also be sex discrimination, because forcing a woman to change, coercing, tricking, however you do it, women to undress with men is sex discrimination, it's sexual harassment. And so they'll go to court on both of those. And if anyone read the Times today, Mridul Wadhwa, who ran Edinburgh Rape Crisis, has been suspended. Times called him a man who identifies as a woman. And so then I think that, there will be more cases testing these rights, but the other right that hasn't really been tested yet that I think will need to be is Article 3. So Article 9 and 10 are about belief and expression. Article 3 is about torture, degrading, and humiliating treatment. Forcing women to undress with men is humiliating. If a woman goes into a doctor and says, I want a female doctor, and is told you're getting a female doctor, and the person they get is male, that's humiliating and degrading treatment. And that's an absolute right. It's not a limited right. You don't balance our rights up against the rights of the other person. That is an absolute right. And I think that will have to be tested. And so that's why after my case, I co-founded Sex Matters as a human rights organisation. We want to protect women's rights, but we think that the framework of human rights is a powerful way to do it. And that's what we're doing.